Article 34.1 of the model law provides that the sole recourse to a designated court against an arbitral award is an application to set aside. This remedy is one of the instances when judicial intervention is allowed in arbitration. Under Article 34.3 of the model law, this application to set aside may be filed within a limited period of 3 months from the receipt of the arbitral award or the disposition of the requests for correction, interpretation, or additional award. Please note that in Article 34.4 of the model law, the court before whom this application has been filed may suspend its court proceedings when appropriate and upon a party's request to allow the tribunal to conduct additional arbitral proceedings or to take any other action which will eliminate the grounds for setting aside.
The IBA rules. So why do we talk about this soft law? The truth is that they serve as a benchmark. They've had wide adoption, dealing with evidence to help guide both tribunals and counsel on what to expect in the proceedings. And so it provides that bridge, often what soft law does, to fill in gaps as needed. Interestingly, the IBA rules here, they're applied both in the commercial and the ISDS context. Take into consideration that the IBA rules were introduced first in 1999, then updated in 2020, and a lot can happen in a span of 10 years, as we look also then to any revisions that will be forthcoming. We talk about, in general, ideas of admissibility of evidence, this notion that it's up to the arbitrators, that the tribunals have discretion.
So before the arbitration, what I mean here is before you have a tribunal, before the arbitration actually begins. So you have a lot of issues going on before the tribunal is constituted. One, of course, is constitution of the tribunal itself. Sometimes parties will want the court to actually choose the arbitrators, particularly if the parties cannot agree. This happens quite often. And also, particularly in what we call ad hoc arbitration, not institutional arbitration, which we'll look at later on. Another very important role for the courts before the arbitration begins is they might be called upon to analyze and determine the validity of the arbitration agreement.